We have had one or two questions coming in, which, as Jonathan mentioned at the beginning, we won't be able to take them all within the time available, but we'll certainly try to take as many as we can.
Yeah,
Jonathan, do you want to take a first question?
Thank you. Several people that Alex was talking about, which you mentioned the St. Albans and ICL case. To sort of synthesize all those questions into one, Alex, could you talk a bit more about the limit of liability of 100,000 in that case and why that was unreasonable, in the context of the Unfair Contract Terms Act, the reasons
yes.
issues? Thank you.
Certainly, Jonathan. I'm happy to run you through how the Schedule 2 reasonableness test was applied in the St. Albans case. I'm just digging out my judgment here from my file, and I can see that it was held that ICL was said to be a large company with substantial assets, and as both you and I, Jonathan, have mentioned, ICL had insurance cover of up to £50 million, and so it's held to be in a better position to bear losses than St. Albans. So there was a policy decision at play there. The limitation of £100,000 was held by the court to bear no relation to ICL's insurance cover of up to £50 million, and ICL had not attempted to justify that difference in the contract. The Schedule 2 guideline of bargaining position was considered and was held by the court that ICL was in a strong bargaining position and that St. Albans had been under time constraints to accept the terms of the contract and therefore to keep up with its community charge timeline. St. Albans was held not to have had any opportunity to get better terms elsewhere because other suppliers were offering similar terms with the same cap of £100,000 on liability. And just finally on that point, as I said in my presentation, the key message from this case is that what is deemed to be reasonable will ultimately hinge on the specific facts of each case.
Vanessa, a question for you in relation to direct and indirect loss. You talked a bit about the difference between the two and also indirect and consequential. A question as to whether one is able in a contract to effectively pre-allocate or pre-categorize what is direct loss and what is indirect loss. And if you can do that, whether there are risks or problems attached to that.
Yeah, Jonathan, you're right to say that you can pre-allocate losses in your drafting of your agreement. So if, for example, you anticipate that one party may incur a specific loss as a result of a specific event, then yes, absolutely, I would certainly advise you to include that in the agreement and to set out what those specific losses are and who will bear them, et cetera, et cetera. I do think that's a good idea. The risk, I suppose, is that actually there is a dispute and that the court takes a different view, much in the same way that the court did take that view in terms of the Centrica and Accenture case. But I think certainly the court will have a look at what was contemplated by the parties at the time, and if it was agreed between the parties that actually one side or the other would actually take certain losses as a result of a certain event, then I think it would be difficult for the court to find substantially different to that.
Thanks very much. Richard, one for you. There's a question which in short form is, why do some parties say no indemnities? The question itself is a bit longer than that, so you might have, having read it, want to phrase it a bit differently, but in essence, what's the answer to that question?
Yeah, I think there's the other aspect of the question, I think, is, if I'm trying to get an indemnity, the other party says, well, look, you should simply rely on the general law, you don't need an indemnity. The question really is, what does an indemnity give you, if you like? If you feel strongly that the other party should accept liability for a particular loss, then it really doesn't matter what you call it in a sense, because there's certainly ways in which you can get the other party to assume responsibility for a loss without using the word indemnity. But in essence, that is what indemnity is all about, is allocating a specific loss and saying that that is the responsibility of one party. I think a lot of people think there's more magic, if you like, to the word indemnity than perhaps there is. I mean, the way I always look at it is to say, apart from allocating risks from one party to another, it doesn't really do that much more. It doesn't always, for example, as some people say, remove the obligation to mitigate, for example. It actually depends on sort of underlying contractual obligation from case to case. And there's the context of the indemnity is very important as well, because you've got other clauses in the contract which say that your liability is capped at a certain point, and the indemnity is subject to that, and if there are other exclusions or if there's other clauses about mitigation and context of claims, those other clauses can sometimes be more important actually to the outcome of a claim than the indemnity wording itself. So it's a complicated area, but I'd say if you're in a position of desperately wanting to get another party to assume liability for something and they're desperate not to use the word indemnity, you certainly can do that. It's just a question of being expressed and making sure that they understand that they do assume responsibility for the loss in question.
Thanks so much. I mean, I certainly agree with that. Some of the larger organisations that one deals with, they have almost as a policy no indemnities, and when one gets below that, you'll find that they will in fact assume responsibility for the liability that you're concerned with, as long as you don't use the expression indemnify or the word indemnity, so you get to the same result. There was another question about liquidated damages and the circumstances under which they might be unenforceable. Do liquidated damages have to be a reasonable assessment of loss? The answer to that question is that liquidated damages are supposed to represent a genuine pre-estimate by the parties of the level of loss likely to flow from the relevant contract breach. However, the point at which those liquidated damages might be deemed to be unenforceable is the point at which they are construed as a penalty clause, and that situation only arises if the level of damages which are provided for is above and beyond the maximum level that the party entitled to liquidated damages might possibly have suffered. So if in fact the parties put in a level of liquidated damages which is within that range, then it doesn't matter if at the point the breach arises and liquidated damages become payable, whether the level of liquidated damages is actually above or below the actual level of damages suffered in that situation. The concept, though, is that the liquidated damages must not function what they call in terrorem. In other words, it's intended to be an outright deterrent or punitive impact on the contract breach.
Thanks, Jonathan. There's a questions come in about the trend that's quite common now, particularly in outsourcing contracts, for customers to list specific failures or defaults as being direct losses. And the question is, do the courts enforce that? And the answer to that is simply yes. If the parties have decided that the supplier will be responsible for all defined direct losses, and if the contract sets out what those direct losses are, then yes, the court will enforce those, whether or not they are in the sort of conventional terminology, direct losses. And in fact, you see this more and more now, people beginning to define what they mean by direct losses in the contract, and it's very much a trend towards customers being a little bit cheeky, actually, and putting in to a definition of direct losses in the contract things which are clearly not direct losses and are indirect losses. So it's an important one to watch out for. It's one you need to negotiate hard on, because the court will respect the definitions that the parties have given to, in that case, direct loss.
Thanks very much. We'll need to close our Q&A session at that point. The PowerPoints that have been on your screens during the presentations will be emailed to all participants after we close. For those lawyers who've stayed the course, I'm pleased to say that the webinar is accredited and qualifies for 1 hour CPD. Our SRA accreditation code should be on your screens now, and will also be in the pack emailed to you. Our next SmartLaw webinar will be our annual commercial law update in December, and we'll be sending around details for that event in due course.